Let's actually switch things up a little bit. Let's talk about whole women's health, because I know there's
you're going rogue.
Yeah, there was a Supreme Court opinion that was just handed down at the end of last week. There was a lot that happened last week, right? Justice Smollett came out. The Josh Duggar conviction happened as well, and whole women's health. The Supreme Court came down with their opinion, which was kind of a mixed bag. It sounded like, right? Kurt, I think you covered this quite a bit.
Yeah, it was, well, let's discuss what whole women's health was trying to decide. So it was a procedural issue rather than a substantive issue. So the question is, can certain people be sued? And who can properly be sued? So the question wasn't really what is the law as it relates to abortion in a substantive way. It's like, can these people be sued at all? Right. So let's just clarify that.
Right.
So what they said, so Whole Women's Health, which is an abortion clinic, sued a whole bunch of people. They sued the attorney general. They sued like the various heads of health and human services, head of nursing, head of whatever, various government officials that are head of various medical departments, and one random guy for some reason,
a private citizen
who had made some, or he had been an activist in this area. I think
he was mean to women.
He's also signed a declaration saying that was just all talk, and I'm not going to do that. So it kind of kills your standing issues. But anyway, so they went to the U.S. Supreme Court, and what Whole Women's Health had gotten from the district court, because now the Supreme Court's acting as the Court of Appeals, right? So they basically skip it up. And so now the Supreme Court's acting as the Court of Appeals. So what the district court said is, well, we're going to enjoin the judges and the clerks. We're going to put an injunction, prevent them from hearing the case, prevent from filing the case. And there's a fairly famous procedural case called Ex parte Young, which basically says in so many words, you can't do that. You can enjoin the executive, but you can't enjoin the legislative, and you can't enjoin the judicial. That's like not a thing. If the judicial screws up and they violate federal law, you can appeal that, but you can't stop them from hearing the case in the first place, not for the least of reasons that the judges themselves are bound by oath to uphold the Constitution. So you don't know going in that they're not going to, make the same decision the federal court would. I mean, there's no reason to think it, obviously. So anyway, so the U.S. Supreme Court said, you can't sue the judges and the clerks because ex parte Young. So just no, that's not going to happen. Because you can't sue the attorney general because they have no enforcement power, but you can't sue the guy because the guy says I have no interest in any of this, so he doesn't count.
And you kind of have to take that at face value, right? His declaration there, you kind of have to, because I mean, what else can you say? Like, no, you're lying. You fully intend to sue under this law.
But you can sue the heads of the various health departments. So you can sue the head of pharmacy. The head of pharmacy was in this thing. The head of the nursing was in this thing. I think the head of doctors, the disciplinary board, a couple people like that. So you can sue these people. Now, for me, if I'm Texas, I think this is relatively easy because the way I read SB 8 and the clear intention behind SB 8 is to make sure that nothing in SB 8 can be brought up by anyone ever. Like, this is not a cause of action for the state in any context. And so that's the way I read it. So if you were trying to discipline a doctor, so this is the scenario, right? You're trying to discipline a doctor, you're trying to discipline a pharmacist because in some way they facilitated this. And so now the state is trying to bring them before the disciplinary board because they violated SB 8 in doing that. If I'm the attorney general, it's real easy. No, they can't do that. SB 8 by its clear letter and clear intent says that the state has no power. That includes all these disciplinary boards. So if your basis for trying to discipline some doctor or some pharmacist or whatever is based on SB 8, just go away. You can't discipline them for that. So I think it's a really easy thing for Texas to just basically concede the issue and, go home.
Basically say
whether or not to do that, I don't know.
Basically say that's the law we wrote already.
Yeah,
we wrote a law which says we're not going to do anything. Now you're bringing a judicial action to try and stop us from doing anything. Well, the law doesn't empower us to do anything. We're not expecting to do anything. The executive branch in Texas is gonna sit mutely by, and it's a private right to the citizens to bring a civil claim against the doctors or anyone else who's involved, the pharmacists in theory. But that since the state is standing by, what? That's how the law is written. So now
However,
you want
one important. Go ahead, Nate.
No. My whole thing is what Texas is doing to abortion is now what California has just introduced to do to the 2A.
Yes.
So exactly what's going on in Texas, California's just literally taking that legislation and said we're going to do it for the Second Amendment.
We called it, right?
Yeah, I called that immediately.
It's good for the gander. Yeah. I don't even know what a gander is, but
a gander is it's a female
group of
goose.
geese.
A group of geese.
I know I'm joking. Yeah.
Okay.
I looked it up.
So I
a gander
will
is
say,
a male geese.
I thought
A gander
a
is a
goose
male
was
Or is it
male.
a female geese? Because a goose is a
goose.
male goose.
Yes.
No.
Yes.
Okay. Now
think a
that
gander
is
is a
sufficiently
swan.
unconfused.
I think a gander is actually
Moving on.
but
And so was I when I was looking at this legislation, because I was thinking, before I got on with Kurt, I'm trying to read this and I'm thinking it's the substance, because we all want to argue about the substance of this, like whether this is substantially a good idea or not, right? In terms of the actual beef, right? We want to get into, okay, does this pretty much hampering, pretty much having a chilling effect on the ability of a woman to go and receive an abortion, right? Like, what's the actual impact on that right? So I think that's what we wanted to argue, but this was a procedure case. Like Kurt said,
right.
It's not sexy, it's procedure. So we're going to get to the substance though.
One thing that was very interesting coming out of this opinion, however, is that there was a portion of the statute that has been effectively rendered obsolete, I guess you could say, which is the portion of the statute that says that only the woman can use constitutional rights as a defense, because the SCOTUS opinion did say that the healthcare providers can use they can use the Constitution as a defense for they can. Sorry, I'm not saying this artfully at all.
Cause of action that they have standing. Sorry, they have standing.
Well, they have standing, but the actual claim that they can make is that they can actually defend against a claim on the basis of constitutional rights, that this is impeding someone's constitutional rights through the activities that they are.
Yeah, I mean, of course you can.
This is third party standing.
You don't need. Yeah, you don't need to say that, but it's. I mean, whether it's in the Texas Constitution or the U.S. Constitution beats statute. Mm-hmm. So if the statute says, "Hey, you can't raise this challenge," and the Constitution says you can, guess which one wins?
Well, of course, your Constitution.
And the pre-enforcement claim itself, so not even just in defense, but a pre-enforcement claim can also challenge the statute's compliance with the federal Constitution. So those I think were all things that the statute was trying to.
I don't quite think that. I mean, because again, the pre-enforcement challenge was for potential disciplinary action by these maybe you're saying the same thing as me or not, but this potential disciplinary action by these various medical boards against various nurses, which obviously hasn't matured, but the nature of the pre-enforcement wasn't for, conducting the abortion itself or in terms of liability under the statute. The only issue was disciplinary action.
Well, but in this case, though, I mean, they did maybe it was dictum, but they did say that they can use it as a defense as well, notwithstanding what the statute says.
Okay.
Yeah. So they can use it as a defense, even though the statute tries to prevent that from happening. So that'll be interesting if any of these entities do end up getting sued, or if I don't know how many of them have actually been sued at this point for doing any abortions. I know there was one doctor who wrote publicly that he had conducted one, and I think
which
sued.
Obviously now he has a real case. He has a real controversy, so he can bring that up, and he can bring defenses into the district court, and then he can appeal that issue, and he can even appeal that to the federal courts. Because ex parte, not Young. What's the other one? I've had a brain fart.
Oh, Grupo Mexicano.
that's not the one I wanted now. But yeah, they can do that. They can bring it to federal court because there's federal issues for review, so it should be fine.
Yeah. So anyhow, that was an interesting opinion that came out. And
also, by the way, just as a side note, there was also a parallel case called U.S. versus Texas, where the United States government sued Texas for violation of the federal constitution, violation of federal rights, and that got what we call digged, dismissed as improvidently granted. The Supreme Court never heard this case. We don't know what you're talking about. So yeah, the Supreme Court bounced that and said, go away.